Hey y'all, Rob here with ATX Legal and here with part 4 of the DWI guide talking about discovery and motions to suppress. Now discovery, all that refers to is all the evidence that the police are turning over and the prosecutors are turning over to the defense. It used to be that they wouldn't turn over very much, and then when they would turn things over, they would only let us look at it and then we'd have to turn it back. Nowadays, after what's called the Michael Morton Act, we basically get almost everything they have with the exception of work product, and that's a technical legal definition, which I won't get into. Just think basically we get everything they have. And that includes offense reports, that includes body cam footage, dash cam footage, and the blood alcohol tests and everything that goes into that. Now first we'll talk about the offense report. That's something we get in every single case. It's written by the police officers who made the stop and who did the DWI investigation. Now you got to keep in mind these offense reports are written to support the prosecution. After you read any of these offense reports, people are going to sound guilty as hell. It's just the way they write them. They're going to make it, every little minor sign of intoxication is going to be sort of blown up out of proportion and it's going to look bad. It's our job as the defense attorney to poke holes in the offense report, not just from the offense report, but from the other evidence we receive. And what evidence am I talking about? Mostly I'm talking about the body cam and dash cam footage. Because a lot of times, no matter how the police write up the footage, that body cam, that dash cam might show a different story. But it is a double-edged sword because if the video shows someone who's truly slurring their words or maybe falling over, really incredibly intoxicated, the video will show that as well. So if you have been charged, just think back to the night you were arrested. How did you look on camera? Because everything was on camera. If you were polite, if you weren't slurring your words, if you looked normal, if you weren't disheveled, all of these things can work for you. However, if you were stumbling, if you were slurring your words, if you told the police you just had 3 shots of tequila and you jumped into your car, things like that are going to work against you. So everything's on camera, everything was recorded, for better or worse. These videos can often help your case, they can often hurt your case. It's just a case-specific situation. And the last bit of information that is in almost every case is going to be the blood alcohol concentration test, or the BAC test. That'll be the breathalyzer if you consented. That'll be the blood test if you did not consent but they went and got a warrant. If there is no BAC test, that is a big factor. You can get much better deals in plea negotiations, or if you go to trial, you'll have a much better chance of winning if there is no BAC test. That's why we always say to refuse those. But if there is a BAC test, there are ways to explain that away if it's above 0.08, or to challenge that test in other ways. And we'll get to that with motions to suppress. And lastly, every case is different. So there might be 911 calls in some cases saying, hey, there's a guy swerving through the neighborhood, or maybe there's empty beer cans or a receipt for alcohol in your car. Things like that. Miscellaneous evidence can come into every case. Like I said before, every case is different. So you have to think about each case in its totality, and things like that can be a factor in your case. And lastly, we'll talk about motions to suppress evidence. Every case is different. Not every case will have an issue. For example, if there is a traffic accident, obviously the police have the right to come up to the vehicle. There's no questioning whether that stop was valid. However, if they pulled over a car, whether it's for speeding or swerving or whatever reason they have to pull over the car, they have to have that probable cause. They can't pull over a car without having a real legitimate reason to pull it over. So if they don't have that legitimate reason, you can file a motion to suppress all the evidence. And while that doesn't necessarily mean that your case is thrown out, usually you're going to get the key evidence thrown out, meaning any kind of interview with the officer, any blood alcohol test, any video of the stop is going to get thrown out. So what the prosecution will do most 99 times out of 100 is just dismiss the case if the stop was invalid. Now the other thing to keep in mind is the police have to have probable cause at each step of the investigation, meaning they don't just need to have probable cause for the stop. They also have to have probable cause that you are intoxicated to begin a DWI investigation. So sometimes we're not able to suppress the evidence based on the stop, but we can suppress it based on the fact that they had no evidence that the person was intoxicated to begin a DWI investigation. And the last type of motion to suppress that is common in DWI cases is to suppress just the blood alcohol test. So that could be because the test was administered improperly, whether that's the breathalyzer or the blood test. Perhaps they didn't give the proper warnings when they were administering the breath test. If it is a blood test, there's a checklist of things that the phlebotomist must do as they're drawing the blood. And if they don't do these steps exactly, the procedure is off and that blood test can be thrown out. It's especially common when a person is injured in an accident and has their blood tested at a hospital, because those phlebotomists don't follow the same procedures that the phlebotomist at the jail will follow, and therefore a lot of times they make a mistake somewhere in the process, or they didn't record something correctly, and that blood test can be thrown out. So those are the three main types of motions to suppress. If you can get any of that evidence thrown out, it can strengthen your case. Now, just because the BAC test is thrown out doesn't mean that the prosecution can't proceed. They can still go forward with the video from the scene and the offense report and the police officer's observations, but it definitely weakens their case if they don't have that BAC test saying this person was above 0.08, 0.15, or whatever the BAC test shows. None of this has been legal advice, but if you do want legal advice on your particular case, you can visit us at atx.legal. If you have other questions about your DWI, you can click below for the link on the DWI guide, or check our other videos that go into other topics about Travis County DWIs.